Hello and good morning, everyone. My name is Jillian Bender-Cormier. I'm brand manager with Bender Insurance Solutions. We want to welcome you to another educational BenderU webinar. Are you prepared for a Cal OSHA inspection? Some housekeeping notes. At the end of this webinar, we will have an engaging Q&A session that I will be facilitating. If you have any questions during the webinar, please feel free to type them into the chat box or in the Q&A section. We'd like this to be an interactive experience, so our presenter will be available to answer your questions in real time throughout the webinar. During our additional Q&A time at the end of the presentation, I'll be sharing other questions you might have with our speaker. We want to be conscious of time, so if we don't get to answer all of your questions, we will gladly reach out to you individually after the webinar. You are all in listen-only mode and will remain muted throughout the webinar. This session is being recorded. And at the conclusion of the webinar, the recording link, as well as a copy of the slide deck, will be forwarded to you. We have a wonderful expert sharing with us this morning. I'll let Bender's own construction risk specialist, Chad Watts, do the honor of introducing him. Welcome, Chad.
Good morning, everybody. We are thrilled to introduce Jeff Ekman. Hopefully you can all see him there. Jeff, whom many of you already know, is a safety consultant local to the Sacramento area with over 7 years of experience in both construction and general industry. Jeff's helped hundreds of companies over the years with written safety programs, trainings, and safety inspections, to include helping with OSHA citations. So I've had the pleasure of working with Jeff for many of those 7 years that he's been at it. I love working with Jeff, and so I was really grateful he agreed to do this for many of his clients and our clients. So I'll turn it over to Jeff. Jeff, it's up to you now, buddy.
All right. Hey, thank you, Chad. Thank you for having me in today. So basically what we're going to be talking about today is, what do you do when OSHA shows up to either your facility or job site, right? I know that can be very intimidating for some. The biggest thing is, we're going to talk about how to be prepared and what to expect, right? But before we get in, I wanted to cover, so this is the top 10 citations. This is for last year, right? The biggest one is always not having a written injury and illness prevention program, okay? Followed up by a written heat illness prevention program. These are very, very basic programs that everybody should have. There's no reason for not having it, okay? The other ones is construction injury and illness prevention program. So if you're in the construction field, it's more high risk type of things that you're doing, you have to have specialized programs written for that, okay? Also have control of hazardous energy, so not having a written lockout tagout procedure, okay? Hazardous communication, so your safety data sheets, emergency eye wash and shower equipment, okay? Reporting injuries. That's a big one right there. They did change the requirements for when injuries need to be reported as far as the time frame. And we're going to talk about that one, but that is a citation amount of $5,000. There's no getting out of that if you miss the window to report an injury. Okay. Respiratory protection. So providing respirators, having written programs on that. Portable fire extinguishers, and then permits to operate air tanks. Okay. So those are just some of the top 10 over last year that companies were cited for. Right now, the big one is that, why would Cal OSHA show up? Okay, the first one is that if it's an immediate danger situation, okay, so that would be there's an unprotected open trench, employees are working at heights without fall protection in place. Okay, it's something that could seriously injure or kill somebody. They will come out and kind of inspect that. Okay, the other one is that if one of your employees is injured, okay, if they get taken away by the ambulance or fire department, okay, that's automatic. That EMS service, they notify OSHA of that, okay? If your employee, if they do get injured, and you take them to the hospital and they're admitted, okay, that being the big one is that once they're admitted, okay, that's automatic. You need to notify OSHA. And it used to be if they were kept for overnight observation, but now it's down to 8 hours. So you have 8 hours to call and notify them. Best way to do that is you can go on the Cal OSHA's website, and there's a section in there that shows you how to notify them that. So you can either email them or call them. We always tell clients, even if they're unsure, like, hey, you know, my employee, they fell, they broke their leg, they're in the hospital, they're getting checked out. Should I notify OSHA? We always tell them, hey, go ahead, give them a call, just let them know. We've had it to some points where they just go, hey, thank you for letting us know, or all right, hey, we need to look into this, depending on what the injury in it is and what caused it. Okay, so that's where they may show up to your actual job site or facility. They want to see what caused it, what were the parameters. Like if somebody fell through a skylight, they want to look at that area. Okay. The next one is that worker complaints, and this is a big one where it could be something as simple as employer not providing the employees with water or not keeping the bathrooms cleaned and supplied. We see a lot of calls come in on that. Is usually water and bathrooms. Okay. So what happens is that a worker can send out anonymous email or phone call to Cal OSHA. If that's the case, Cal OSHA, they have to come follow up on it. So you will either get a letter, a phone call, or they show up at your place of business. Okay. The other one's referrals, and we're going to cover these a little bit more in depth in the following slides. So referrals, targeted inspections, and then follow-up inspections. Okay. So like I was saying with the immediate danger, okay, that could be any kind of hazard that was caused death or serious physical harm. Those receive top priority. So it could be something called in. We see a lot of times where another trade or an employee will say, hey, you know, my employer, they're making me work at heights. They're not providing us fall protection. Okay, if that's the case, OSHA, they will come out on that, right? Employers are to correct hazards immediately or removed endangered employees, okay? If you do not, that's when you can get serious citations, especially if somebody is injured after you've been told, okay? Now we talked about with severe injury or illnesses, okay? They define it as inpatient hospitalization regardless of the length of time for other than medical observation or diagnostic testing, okay? That's their new definition of it. Also, you would need the call if there's any amputation, loss of eye, or permanent disfiguration, okay? So you must notify them, the employer, immediately upon a knowing, no longer than 8 hours, okay, of any serious injury, illness, or death, right? That's the big one, and I see a lot of clients end up missing that 8-hour time frame, and they don't call them for like a day or two after. That right there, it's a $5,000 citation. There's no getting out of that, okay? Now, as far as workers' complaints, okay, they have a right to report unsafe working conditions, and a lot of times what I've seen in the past is an employee get fired, they get disgruntled, so they end up calling and reporting their employer to OSHA. They make up a complaint saying, hey, you know, they were exposing me. It could be something like I've seen it, wood dust in a manufacturing. They call in and say, hey, they're not giving us clean water, providing it, okay? Cal OSHA, if that's the case, they will come to your facility. They have to follow up on these. And I've seen some of it where they kind of go, I feel like this is disgruntled employee. So they'll send an email, okay, to the employer saying, hey, we had a complaint. Here's the complaint. Please respond with either written response or showing pictures and documentation. And it could be something like, hey, we want to see how are you providing the water? Where's your written heat illness program? Fall protection, are you providing that? Where are the receipts for the fall protection? So it's something that you're able to show them, hey, we are doing what is required, okay? Because if not, it can open into a can of worms, kind of, okay? And the other thing is that because employees, they may request an anonymous when filing that complaint, so they don't even have to say who filed it. And we do get a lot of those, okay? The other one is that it could come from a referral. So it could be from the following. It could be a federal, a state, local agencies, individuals, organizations, and media. A lot of times what we hear is union reps coming out to jobs that are doing non-union work and them kind of playing hardball and calling Cal OSHA out. I've seen that on multiple jobs, okay? We had one where they came out, they went through everything. I've been working with them for a while, so they weren't able to find anything. It was actually the trade that was unionized that called them. They actually got a couple citations for issues they had. So it pays to be prepared. Okay, the next one is targeted inspections. Okay, A lot of times, every year, usually when we have a big heat wave, where we're going to have 100-degree or plus for a couple days, okay, OSHA does come out and they do sweeps. It may be targeted in either Southern California, Central, Northern. Basically what it is, they show up to the job site, they go through every trade there, and they ask very, very specific, hey, we need to see your written heat illness program. Where's your water? Where's your shade? If you show all that, they move on to the next. Another one we saw is they did sweeps, I think 2 years ago, where they went to every single countertop manufacturer in the Central Valley looking for silica because of the new regulations that were passed in 2017, just to make sure that they were in compliance. So they can actually target those different industries based on what they're seeing. Okay. The other one is that they could do a follow-up inspection. Okay. So if they came out and saw multiple issues, if you were given a citation on any of those, okay, they can come back at a later date and check to make sure that you corrected all of those. If you don't, it's not good. So any questions on those so far? If you do, please send those questions over. We'll ask them as we go. Okay. If not, we're going to go into when they actually show up. Okay. And kind of how to survive that. Right. I can't stress this enough. The key is to be prepared. Right. If they do show up, don't freak out. Okay. They're there for a reason. The biggest thing is find out, what they're there for, what they want to see, and just be polite. Can't stress that enough as far as being polite to them. Okay. It's kind of like when you get pulled over by CHP, right? They're going to ask you, hey, do you know why I pulled you over? You don't start going off on everything. You don't tell them, hey, I don't got time for you. Okay. Please don't do that. Just be courteous and polite. The regular individuals, they're just doing a job. Okay. So what should you do before they show up if you know they're coming? Because that's the other one, is that if you did have a serious injury, okay, and if they were notified, and there's a potential that they may show up to your job site or facility, okay, please call me. I've done this for multiple clients. I come in through either the job site or facility, do a complete walkthrough, check for any hazards, try to get everything cleaned up if we know that they're coming, so it limits your liability on that, okay? The other thing is that if you know they are coming, make sure your programs are up to date, okay? Because if they start asking for them, you want to make sure that your IIPP is up to date. There have been some recent changes on that. You do have all your written programs are current. Okay, the other one is we find a lot of times companies that put together their safety programs, they go to just OSHA.gov and they pull OSHA regulations out. Okay, the problem with that is that if you're in California, they have to be Cal OSHA regulations. So be careful when you're doing that. We've had it before where a client was going to send over all their records and programs and everything. They sent it to me first to review it. We found out, hey, don't send these. These are all OSHA. These are Fed OSHA regulations. You need Cal OSHA. Okay, so just be aware of that. All right. Now, when they do come out, okay, the first thing is they need to begin an opening conference, okay? And we're gonna deep dive into each one of these, okay? So opening conference, examination of records and written programs, so they're gonna wanna see those, inspection of the facility, and then they give a closing conference as to what they saw and what you're gonna be potentially cited for, all right? So that opening conference, right? Biggest thing, like I said, is if you do find them, they may be doing a target inspection, could be follow-up on a complaint, or they're out there doing investigate a serious injury or death, okay? Biggest thing is greet them in a friendly and courteous manner, okay? Don't be rude, don't tell them I don't have time for you, come back tomorrow, okay? Don't do that, right? The other thing is check the inspector's credentials, okay? They do have to carry an ID on them, okay? You do want to check for that because we had a couple of years ago, there was a couple running around in California, they were doing a kind of a scam where they were saying they were Cal OSHA, they were coming in, to facilities, writing them up on saying, hey, we got you on $100,000 in citations. You can pay right now and settle for $10,000 if you write a check today, okay? So they do have to show you those credentials. So always ask for them. You don't have to be rude about it. Just ask them, hey, can I verify that you are who you say you are?
Jeff, we have a question.
Yes.
From James. Are you seeing or hearing roofing contractors getting hit with silica inspections / fines? How much is the fine?
So I haven't really, they haven't really targeted the roofing industry as much as they did for the countertops. And I know if you're doing tile roofs, okay, you fall under the silica standard. The biggest thing is that what we're seeing is they want tiles to be cut with either a vacuum or a water system. Okay, but the thing is that roofing, we don't want to take water up on there. So it becomes an issue to where I've seen where they just put them in N95 mask. The thing is that you can be cited for all that if you're not following the guidelines, but I haven't really seen them targeting the roofing industry. Okay, if that answers the question. However, that doesn't mean you're just out of sight, out of mind. They can still, if they do see it, you know, they can come out and they can cite you for it. Okay. Now continue. So the opening conference, biggest thing, ask them, you know, what are they there for? For the inspection, is it targeted, complaint? If it is a complaint, they do carry a copy of that complaint so you can see exactly what it is. Okay. The other one, notify your risk management and affected departments, depending on where you're at. And I'll give you an example. We did have this a couple weeks ago. I do work for a lot of the home builders. I had one of them call me saying, hey, OSHA's on our site. Can you get here? Tell them, hey, you're in luck. I'm actually 5 minutes away. So I came on there, found the OSHA. There was 2 inspectors, right? And the first thing, you know, introduced myself. Hey, safety coordinator for this builder. Can I help you? Who are you looking for? What's your reason out here for the day? They said, yeah, you know, we're out here. We're looking for one of the subs. We're following up on a complaint. So, all right, hey, can we keep you right here? Let's bring the sub to you because I don't want them walking through the whole job site. Because whatever they see, they can't cite you. Okay. So the other thing is set the ground rules, right? Scope of the inspection. Are they doing industrial hygiene monitoring, photographs, video, etc.? What are they there for? So we had a lot with the countertops, right, where they came in and they wanted to do industrial hygiene monitoring. So they were checking for silica dust content in the air, right? So if that's the case, you want to keep them, hey, this is what you're here for. Let's keep you on track with just that. I don't want you going and wandering around the whole facility because, like I said, anything they see out there, they can cite you for that. So it's kind of like on site with the home builder, right? Say, hey, can we keep you here? I will bring the other trade to you. I don't want you circling around the whole job looking for them. Okay. Like I said, the biggest thing is cooperate, right? There's no need to be mean. However, the inspector's job is to find things wrong. Remember that. So when they do, because the thing is, when we had the 2 Cal OSHA guys on site doing the complaint, you know, this guy's looking at, hey, the scaffolding's kind of messed up. When we drove in, we saw exposed J-bolts on the concrete slabs. Those need protective caps. Told them, like, hey, if you're out here for the individual sub, let's stick with that. If you want to go into the scaffolding or anything else, you can open up an investigation and a conference with the builder themselves. So just keep that in mind, especially if you're a general contractor on site, right? Be honest with them, forthright. So if they start asking for documentation or are you doing this, that, don't lie to them. They're going to know. They go through multiple sites, investigate multiple injuries. So they're going to see right through it if you try to fluff your way through an inspection. So be prepared, okay? They say over half of all Cal OSHA cases are made based on management admissions, okay? If you admit you're wrong, they're going to get you on that. Don't ever admit. Right? If there is an issue, okay, they do take pictures, they cite it, okay, you're gonna have to just roll with it. Don't sit there and say, oh yeah, that's my mistake. We didn't have any of our written programs. We didn't do any trainings. I just told the guy to get up on the roof without fall protection. Okay, as soon as you do that, you're guilty, right? Yeah. The other thing is that if you don't have management, if they're not present or you don't have your in-house safety, the biggest thing is train your foreman how to handle if OSHA comes out, right? I cannot stress that enough. You need to give them a brief. Hey, if they do come out, this is where all of our safety programs are. This is what they may look for. This is how you're going to get it to them. If they want anything else, this is what you do. I can't stress that enough. Like I said, the more you're prepared and the more that your employees know, okay, the better you're going to do if they do come out, okay? All right, now we do get a lot of questions sometimes. Hey, I can tell them you need a warrant to come through my facility, right? And I've even talked to Cal OSHA, some of the enforcement guys on this. They say, yeah, you know, it does happen. They go, we love it when that happens because now they just go get all their buddies. So they get all the other state agencies to come in. So now you don't just have Cal OSHA, you have the labor board. I mean, they come in, they're coming in hard, and they're really going to get you. So it's not recommended, like I said, except in the rare circumstance such as a fatality. That's where, if you do have a fatality at your job, I recommend that's where you're going to want to get lawyers involved in this, because it's going to be a lot bigger than just somebody sprained their ankle or broke a leg. Okay, but be careful with the warrants. Okay. Now, when they do go in, when they're out there, they may ask to see a copy of some of your written programs, right? So the main ones they're always going to ask for is a copy of your injury illness prevention program, okay, and a copy of your heat illness prevention program. Like I said, those are the top 2 citations. So those are the ones that they easily ask for. Sometimes they might not even ask for it. It just depends on the nature of the investigation, okay? Because they could send you later a request for documentation, which we'll talk about, but only give them what they're asking for, right? Remember, your injury illness prevention program, that's not your entire safety book, okay? You just give them the specific sections that they're asking for, okay? If they're asking for, could be log 300s, proof of insurance, proof of workers' comp, stuff like that, only give them what they're asking for, okay? The other one is, and a lot of times we see they'll ask for daily inspections, equipment inspections, tailgate meetings, okay? If you don't have those on site, it's not end of the world. Okay, have your guys tell them, especially if you're running a roofing crew, construction, train your guys to tell them, hey, we send those all into the office. The office has record of everything, okay? All right. So if the company, if they have non-OSHA required documents or requested, okay, it could be your safety meetings, audit reports, statistics, etc. Ask for it in writing and advise the inspector that his or her request may be approved by risk management and the law department. So there's certain, in all of this too, the guidelines that Cal OSHA has to follow, it's publicly posted. So it's not, they don't just come in and start making up stuff. Okay, they have a criteria that they have to follow as well. So there's certain things that they can ask for and request to be shown upon being on site. And there's others that they have to send a request form to your company to where you can release that information. Okay. Under no circumstance should documents, so letters, reports, etc., be created and provided to OSHA without first being approved by risk management and law department. Like I said, if you get a request for documentation from Cal OSHA and you're unsure if your programs are up to date or you have the right programs, okay, please reach out to Chad. Okay, Chad will get you over to me or reach out to me directly. I have no problem reviewing all your stuff, just to make sure that you have the right codes in place and it's updated before you send it out, okay? All right. The other thing is that keep a list of all documents provided to Cal OSHA, because if you do take it to an appeals court, you want to know what was sent over, what they reviewed, all right? And they will read over all your programs with a fine-tooth comb, okay? Now, as far as facility inspections, right? Case of a referral or complaint inspection, strictly confine the areas inspected to the subject in question, okay? Like I said, if they come out, let's say if you're a facility, right, and they come out to, maybe somebody filed a complaint on the restrooms. I've seen this before. They filed a complaint, said, hey, my employer not keeping the restrooms clean. Cal OSHA came out, did their opening conference, said, hey, can we want to review your programs, saw the written programs. Hey, we're here for the restrooms. So the company took them directly to the restrooms and said, here they are, you can inspect it, and then guided them right back out. They didn't say, oh, hey, we have this. Oh, I had a question on this. Okay, just show them what they want to see and then try to guide them out of there. Don't ever take them like, oh, I think this is kind of iffy, but okay, be careful on that. Management representative must accompany the inspector at all times. Do not ever, under any circumstances, if they come out and say, hey, we're here to check this, okay, don't tell them, oh, it's in the back corner, go ahead, right? Do not let them go unaccompanied, right? Allow an employee representative to join in if so requested by OSHA as well, okay? Now, permit interviews, non-management employees upon request. You do not have to intervene with production. The employee has a right to a private interview. So a lot of times too is if they are there doing, could be a targeted inspection or follow-up or anything like that. At any time, one of your employees, they can come up and ask to be a part of that And also they can say, hey, what are the hazards that were seen or found, because they have a right to know what they're potentially being exposed to, okay? They also have a right to a private interview, so they can sit down with OSHA. And a lot of times too, as we see them, like in the recent one and on the building site, okay, they interviewed the sub, they talked to the foreman, okay, so they wanted to know is about their water, said, hey, you know, where's your written programs? How are you providing this water? How are you keeping it clean? What are your procedures if somebody gets heat illness? Okay, checked out on the foreman. Then they went and interviewed 2 separate employees. So they want to ask them as well things, hey, what are you guys doing for training? What do you know about heat illness? So they're following up to make sure that your company is doing what they're doing. So they will interview your employees, okay? Right now, they carry cameras, right? They do take pictures of everything. They document everything. If that's the case, right? Whatever they're taking pictures of, especially if it was an accident. We had one, somebody got injured on some scaffolding. OSHA came out, they're taking pictures, they're documenting, okay? We told the trade, hey, make sure you get a copy of all the notes, pictures, okay? Because you're gonna wanna know, so in case they're missing, they're leaving things out or trying to make it worse than what it actually was, okay? You might wanna take pictures yourself and keep a record of that, okay? And a lot of it too is they may give you a chance to correct the issue. So the one where they came out for the heat illness, they said, hey, you know, there's all the exposed J-bolts on the concrete slab. Okay, they need to have rebar caps over them. OSHA told it was a different builder on site, told them, hey, just letting you know we're out here, that's a hazard, get it corrected. We're gonna be back through here in about 2 hours. If it's not, I'm gonna give you a citation. So a lot of times they do give you a warning on that. If you're able to correct it then and there on site, they leave it alone, okay? So they can be reasonable. Depends on who you get really though, right? Then once they meet with you, they state the reason, they check your records, they interview your employees, they walk through your facility or job site, okay? They are required to do a closing conference, okay? You have to be there for that, right? Be cordial and professional. Don't get mad. Don't get angry with them if they found anything, okay? Do not acknowledge any alleged violation, okay? And do not explain how the violation would be abated, but just ask for suggestions, what you can do better. Hey, how can we correct this, right? The whole reason for them coming out is they're trying to better your facility, your job site. They want to see employees be safe and kept safe. They're not out there to just bury companies in fines, okay? So the whole reason for them is they're required to keep everybody in check and keep everybody safe, all right? During that closing conference, don't volunteer any information other than what they want to see, okay? Make notes of all the inspector's comments, including potential violations, and request that all photographs be labeled confidential. So if you were in a serious, maybe it was a fatality or a serious injury, that's when you want to do the confidentiality, okay? Then after the inspection, okay? So for each violation, the following will be discussed. So they will tell you the nature of the violation, possible abatement measures, okay? So it could be something like the scaffolding. Maybe the scaffolding is not set up correctly. They have to tell you what's wrong with it and how you should fix it, okay? How long you have to fix it. So it's depending on the nature of the issue seen. It may need immediate abatement, or they may give you 30, 40 days, depending on what it is, okay? And then any penalties that are area director issued, right? Now, once they do go through, so say they came out, so this may be for roofing industry, let's say they came by, they saw your guys not wearing fall protection, okay, so they come on, they interview your employees, okay, get all the information. The next thing you may receive in the mail is what you see here. This is the document request sheet, okay? You can find this online too. If you just type in Cal OSHA document request sheet, it's gonna tell everything that they could be asking you for. Okay, so in the example of this, they want to see pay stubs to make sure that they are actually employed and you're not paying your employees under the table with cash. Okay, they want to see, they always ask for your log 300s. Okay, your injury illness prevention program. They want to see training records. Okay, that's always going to be another one. So on top of your, let's say they come out, they say, hey, we want your heat illness prevention program. Okay, submit us a copy of that, and we want the training records for these 2 employees that we saw out there. Okay, so make sure your training records are up to date and current, okay, because they will ask you for that. If you don't have it, that's when you can have an issue and you can be cited for lack of training, okay? But you can see on here, they're asking for different written programs and training records, okay? Like I said, you can find this is online. I recommend go through it once a year, make sure that all your stuff is up to date, your training records and everything, in case you are ever audited by OSHA, because they will send you this. The other thing is that if you do get one of these, I'm always available. You can send it over to me. I can look through it and I can help you pull out of your safety manual the exact programs that they want. Don't just send them over your entire safety program or book, okay? All right, the other thing is that, and I get this a lot, OSHA came out, they sent for the request for documentation, sent everything, and then they just go dark, right? And employers are telling me, hey, I haven't heard from them, it's been a couple months, what's going on? Remember, they have 6 months to issue a citation. They're pretty busy right now, I know that. They do not move fast on that, okay? It's not, you got the request for documentation, you sent everything over, and then 2 days later, they're sending you over what they need, okay? Usually not like that. They have 6 months, okay? If a citation is received, you must do the following. You have 15 working days, no exception, okay? And I'm gonna show you what, so they send you the request for documentation. Okay, the next one is that they're gonna send you a notice of intent to classify citation. So it could be generous, other, or general, other, serious, other than serious, willful, depending on what it is. You can see here, so they got their request for documentation. The next thing that the employer got was the intent to what they're gonna cite them. So they'll put in the description here exactly what it is. So this one was for an issue with scaffolding, okay? Backstory on this, we had somebody's injured on some scaffold, okay? They came out, so Cal OSHA looked at the scaffold. They cited on multiple things wrong with the scaffold, from nails not being in the base plates, missing guardrails. There was also missing daily inspections. They wanted to see that. Okay, so they looked at all those things. Okay, they do give, you have a response, so they're telling you, hey, this is what we're going to be potentially citing you. We're going to cite it as serious. You can explain why it should not be put as a serious citation. Okay, a lot of times on this, what we will do and how we help employers is come in and we'll do additional training. You can purchase additional, so like this one, you could purchase additional or newer scaffolding. Depends on what it is. It could be a fall issue, right? Hey, we went through and we brought somebody in to do a new or an updated fall protection class for all of our roofers. We purchased new harnesses. We went through and inspected them. Okay, so based on that, they're going to give you good faith, and they may take it from a serious to an other than serious citation. Okay, but you
Jeff,
do.
we have a question from one of our guests, Dawn.
Yep.
She says, we are a very small company of 7, including owners. If we do not have any injuries, do I still need to fill out a 300 log?
No, so it's only if you're over, if you're 10 or more employees.
Thank you.
Yep, 10 or more, then you have to do a log 300 every year. Okay. And the other one is that in a lot of companies that maybe they just started up, let's say this is their first year of business and Cal OSHA comes in and asks them for that, okay? You're not gonna have a log 300 put together yet. If that's the case, you just let them know, hey, we've only been in business for the first year. Okay. Now, so back to, you get your notice to cite, okay? So they're gonna send you that. You're gonna send additional documentation, training records, hey, we spent, an extra $10,000 on new safety equipment, training, stuff like that. Can you deduct that from the amount, okay? Or even reduce what it's going to be cited at, okay? And then an informal, and remember, you have 15 days to get that documentation back to them, okay? So everything's on a timeline. You have 15 days, they have 6 months to get back to you, okay? So we have informal conference and settlement, okay? You can request an informal conference with OSHA area director to discuss the citation, okay? So maybe obtain a better explanation of the violation, negotiate and enter an informal settlement or resolve disputed citations and penalties, okay? I can't stress it enough. If they give you, so when you get that intent to cite, they're going to put the citation amount. Okay, don't settle on that. It doesn't mean that you get, and we've seen it. Example of the one with the scaffold, they think they wanted as proposed $83,000 is what they wanted. Hey, we came back. Hey, you know, we did all this training. We put new programs into place. Now we have a written scaffolding program. We purchased extra equipment. You know, can we get these reduced? So they actually did. They took it from that 83. They're now down to 12,000. Then the next one is that going into a rebuttal. So now it's going to Cal OSHA again. Hey, can we get this reduced even further? Okay, so don't settle with that first amount they give you. You can fight it, okay, and try and get it reduced. And I highly recommend doing that. Okay, even if you need help on that, please reach out. I can help you with that. Okay. They also say most citations are settled at an informal conference. Okay, informal conference. It's a general recommended, even if violations and penalties, although it shows good faith. And the big thing is, like I said, Cal OSHA, if they do, you had an injury, okay, your stuff wasn't where it should be with your programs and everything. You're showing good faith. Hey, we did all the new trainings, we got new programs, we're really trying. Okay, they're going to take all that in consideration, and that's when they're going to start reducing those citations amounts. Okay, they're not there to bankrupt companies, especially if you're a smaller company. You know, you got 7 to 10 employees. Okay, if you get an $80,000 citation, they understand that's going to set you back tremendously. To where they don't want that, they want to see, hey, that you're actually keeping your employees safe. So they're going to work with you, and you can reduce that citation amount. Okay. The other one is that if you do receive an actual citation, so you do get cited, okay, remember you have your intent to cite, then they'll send over the actual citation, okay, with the dollar amount, right? If you receive that, you have to post a citation for 3 working days or until fixed at a near or near the place where each violation has occurred to make employees aware, right? So it does have to be posted, okay? You must comply with these posting requirements, even if you contest the citation. It still has to be posted. And I've only seen that done a handful of times. But yeah, it'll stay on the paperwork too. It'll tell you what you have to do, right? Now, when we get into the different types of violations, okay, and what they classify them as, okay, so first we have, and each one of these has a different dollar amount, right? So willful, so an intentional disregard for requirements. Okay, so willful would be if your employees were not wearing fall protection, working above the trigger height, okay, that becomes willful. So you knew that there was, or let's say, I'm sorry, even let's say your employee fell through a skylight, right? Because I've seen this happen. Your employee fell through a skylight because it was unprotected. Okay, that becomes willful because you knew that the skylight was a hazard. You knew that it had to be protected by either guardrails, a cage, or fall protection being worn around it. Your employee was seriously injured. Okay, they will come after as a willful because you disregarded the requirements. Okay, serious is that probability that death or serious harm could occur from that injury or what they've seen. Kind of like the scaffolding, it was missing guardrails. Okay, that's why they were going to classify it as a serious, so it has that probability. Okay, then other than serious, usually put other than serious is your written programs, training records. Okay, they look at things like that. There's usually it classified as other than serious. Okay, then we have the de minimis. So employer has implemented a measure different from one specified in standard. Okay, does not result in a citation or penalties. We have failure to abate. So violation remains continuously uncorrected, right? And then repeated. I'm understanding repeated, I think it's 3 years now. Here's the thing is that they changed you got to be careful on the repeat, right? Let's say that a company was cited for fall protection, let's say for roofing, right? Your employees didn't have fall protection. They're working above 20 feet on a commercial building. Okay, they didn't have fall protection in place, right? You got cited for that. Within that time frame, let's say that your employees, they come back out, they find them in a boom lift and they don't have fall protection, right? That now is a repeat. Okay, they look at not the tasks that they're doing, but the actual fall protection. Okay, so be careful on that. That's where they can get you. Repeat citations are not cheap, and I'm going to show you kind of the penalty amounts right here. So you can look at this. Whereas for the repeat, right, first repeat proposed penalty amount is multiplied by 2, so up to $132,000 for a repeat. Okay, these things do not get cheap. The other one is you look at, okay, and these are the most current citations amount. They did increase the fines just this last year. Okay, for a general, you can see here it's anywhere from a minimum of 500 to a maximum of 13,000. Okay, failure to report, $5,000. Right? If you do not report within that 8-hour time frame, you cannot get that reduced. That one sticks. Okay, it's automatic $5 grand you're paying. All right. Then we look at serious. It's up to $13,000. That's per violation that they find. Okay, remember it's not just they came out. Hey, your guys weren't wearing fall protection. It's $13,000. They're going to look at weren't wearing fall protection, or fall protection was being worn incorrectly. You didn't have a fall protection program. You didn't have a heat illness protection program on site. They go down the list and they're going to tack on each thing, because some of them it may get reduced from that 13 down to a couple $100, or it may get thrown out because you were able to provide that documentation. But you can see where it can get pricey pretty quick. Okay, and then the willfuls, right? $130,000. That's a lot. So if somebody fell through a skylight, got seriously injured, they came out, find that you did not protect that skylight, you did not provide training, you didn't have any of that. Okay, they're going to get you with up to that $132,000. Right? And this can all be found online. It is public, so you can look that up. All right. Do we have any questions on that? On anything that was covered?
We haven't had any questions come in just yet, but folks, please go ahead and send those in. Happy to answer. Oh, we do have one question, Jeff. Mm-hmm. What do I do if OSHA shows up and I don't have any safety programs they're asking for?
Oh, well, sometimes, I mean, if you don't have them, you don't have them. You got to just be honest. That's why I recommend, you know, if you need to have these programs, they're not very expensive. These are things that I help out with. We always do it through Bender. We can come out and audit your facility, your job site, make sure you do other programs. It's not an arm and a leg to get them, and you can look at it as it's insurance against an OSHA inspection. But if you are in the case, you do not have it provided, they're going to send you a request for documentation. So they do give you time to get them put together, and they may slap you with a couple $100 citation because you didn't have them upon request, right? But it's not the end of the world necessarily.
Great, thank you. We have another question that's come in. We were reported by a disgruntled employee for 4 COVID violations that were being followed as best as we could and documented. OSHA sent us a letter of the alleged violation complaint. We sent back documentation specific to the issues in April, but have not heard anything. How long should we wait?
Remember, you get 6 months. They have 6 months to respond. That's the thing, and they're not quick to respond. But we've had that where disgruntled employee, they filed a complaint. It was on extinguishers, first aid kits, water, shade, I mean, everything. OSHA sent an email. Hey, we had a complaint, kind of like with COVID. We documented everything, sent pictures, everything was sent over to them. I think it took them over 5 months to respond back. And it was just basically they said, thank you. That was it. So that's why it's very important that you are prepared, kind of like with the COVID case that you're saying, disgruntled employee, but you were able to say, hey, we have all our written programs, we're following the guidelines, we're documenting everything. Here's everything we have, because OSHA, they do realize that sometimes it may be a disgruntled employee that is trying to weaponize them. You do got to be careful on that. That's why it's important to be prepared.
Wonderful, thank you. Another question we have, Jeff, is how often should I update our safety programs?
At least you should go through it at least annually, just to make sure there haven't been any changes. Because when Cal OSHA, they do put out changes. I know there's a couple new amendments to the injury illness prevention program. And then as far as reporting injuries, so when those change, you do need to update it. That's why it's recommended at least once a year. Go through your book, make sure everything's current.
Great. Another question that we have are, is what are the best ways to walk away without any citations or fines?
Yeah, so preparedness. That's the biggest thing. Be prepared, know where your programs are, know what's in your programs, know how you're handling your safety. If the more you can present to them, the better you're gonna do, right? Because when they start asking the questions on the heat illness, if you say, hey, yep, here we train these guys, we have daily meetings when it's 95 or over, we do annual trainings on heat illness, here's all our water, this is where we provide it. Here's extra postings on site so these guys know who to call if they feel ill or what to do, signs and symptoms. The more you can show them, the more they're going to look at, hey, you're locked on. They're looking for low-hanging fruit.
Okay, great.
They're not going to go after the tough ones. If you got it together, they're going to leave you alone.
Another question we have, Jeff, is what constitutes a repeat violation?
Yeah, so like I said, with the repeat, it could be something as with the fall protection, right? Fall protection not being worn on the roof, you get a citation for that, and then within a couple years, they catch you in a boom lift without that fall protection, they're gonna get you as a repeat. So now that original serious violation, which was $13,000, it can increase to that $132,000. So that's what you had to be careful on those, especially if you had a citation. And what we're seeing a lot now is with those citations, because they're made public on Cal OSHA's website, you can look up any company to see if they've had any citations within the previous 5 years. And I've noticed a lot of general contractors, when they're doing the bids, they will vet their trades and see if they have any open citations, and they're going to want to have that trade send over a letter stating why did you get cited, what have you done to correct it, and how are you going to prevent it from happening again. So they will affect your ability to bid on jobs. I've seen subs not even they're losing bids because they've had too many OSHA citations. So be careful on that.
Great. We have another question here. What's your opinion on inviting OSHA's compliance unit to help identify any violations? Is it opening a can of worms?
No, that's actually a great question. So the thing, and there's a lot of misunderstanding with consultation and enforcement. The thing with the consultation and enforcement, they're separate. They're two separate entities. They do not talk to each other. Okay, one, they don't know what the other one's doing. The thing is that you got to be careful though. If you have enforcement come in and open an investigation on you, you cannot go reach out to consultation. Okay, that's where you call me and I'll help. But consultation, what it is it's kind of like having, if I were to come in, but it's a free service. They basically come in, they're going to review all your programs, trainings, your facility, it could be your job site. They're going to give you a list of recommendations of changes you need. You cannot be cited on anything, okay? However, if you invite them in, the only thing is that you're required to correct any issues, okay? And I think they give you, depending on what it is, up to 45 days. They're just going to want to see documentation that it was corrected, but I highly recommend. I work with consultation a lot. I do a lot of job walks with them. They're great. They're very knowledgeable. They help you out with all the different programs, answering questions. They're a huge resource. So I highly recommend using them, especially if you're starting up a new job site, or maybe it's just been a while and you want an extra set of eyes, or even your facility, you're just unsure of a couple things, bring them in. Like I said, it's free. They're great. You're not going to get in trouble on that. It's a great question. Thank you.
Absolutely. Okay, we have another question. Are copies of heat illness injury prevention required to be at all job sites at all times, or can management have them and provide them after the inspection?
So it is required that it has to be provided on site upon request. Okay, so that's the verbiage on it. So your employees, they have to be able to, it has to be accessible at all times. That is a requirement. So they could cite you for not having that accessibility. So I've seen it. It can be provided on an app, written copy, and we've even done for some. We just made a heat illness binder where we had their program, their written procedures if somebody goes down, and then just kind of some general acknowledgement, signs and symptoms, and what to do. But you do have to have it on site. It is a requirement. If you don't, it's not the end of the world. They may get you for a couple $100, so long as they're going to ask, hey, we want to see a copy of it. That's when you're going to send it over to them, and they maybe get you a couple $100 just for not having it on site. So it's not the end of the world.
Wonderful. Well, Jeff, it looks like those are all of the questions that have been sent in. So thank you so much, Jeff, for sharing with us today. We appreciate all of you for taking time out of your busy schedules to join us for today's BenderU. Are you prepared for a Cal OSHA inspection? As a reminder, this session has been recorded, and a link to view and share the recording will be emailed to you following the webinar, along with a copy of today's slide deck. We know that questions arise after the webinar, and we're here to help, so please feel free to reach out to us, and we'll be happy to get back to you. Thank you again to everyone, and we hope you all have a wonderful day and a safe holiday weekend. Thanks, Jeff.
Yeah, thank you.